All right. Good afternoon. Thank you very much for joining us. I'd like to welcome everybody to the first webinar in our NHS Legal Frameworks webinar series. The title of this webinar is A Masterclass on NHS Continuing Care for Adults and Children. My name is David Locke, King's Counsel. I'm going to chair the session. I'm joined by my colleagues Fiona Scolding, KC, and Samantha Broadford, KC, whom I'll formally introduce in a moment. Now, sorry to disappoint anybody who thought they were going to hear either the Rest is Politics podcast or something like Gardener's Question Time. This is a legal webinar, and although these subjects are almost inevitably politically contentious, we will try. We may succeed, we may otherwise be as provocative as Alistair Campbell and Rory Stewart on the Rest is Politics. And we'll also try to provide as much information as you get from the astonishingly useful and well-informed panel on Gardener's Question Time. But you can only judge how successful we are by the end of the webinar. We have a very large audience today, which is a tribute to the expertise and the standing of the speakers from whom you'll hear in a moment. There'll be a Q&A session at the end, and we try and go through as many questions as we can as possible. Though with so many people, it may be that we don't get through everybody's questions. I apologise in advance. To begin with, can I mention a few housekeeping points? Your microphones are automatically muted, so you don't need to adjust your local settings. As I mentioned, we will welcome questions. Please submit them via the Q&A section at the top or the bottom of your screen. If you'd like to remain anonymous when you're putting a question in, please make sure you tick the Send Anonymously box before submitting your question. The webinar is being recorded, and you'll receive a link to the presentations and the questions at the end of the recording, which you're very welcome, of course, to pass on to anybody who has not managed to join the webinar. If your connection is lost at any point during the webinar, we invite you to rejoin by clicking the original link once more, and touch wood, it ought to take you back in. Now, this event has been marketed as a masterclass, not an introduction to NHS Continuing Healthcare, which we're going to refer to this afternoon as CHC, or Continuing Care for Children, which I anticipate will get referred to as CCC. This means the speakers are going to assume some knowledge of these areas and will concentrate on the areas of difficulty. You should have been sent links to allow you to download the very substantial guide, both to adults CHC and to children's continuing care. And we hope that you'll be familiar with the terms of those guides. If you're not, or if there are others who are attending this seminar who are new to the subject, I very much hope you've had a chance to read up or think about the issues in advance. The guides are based on chapters 16 and 17 of a book called NHS Law and Practice, which I've got here, which is available in all good legal bookshops and probably a few bad ones as well. But you can download and read the guides for yourself when you've signed up for the seminar. If you are really wholly new to the subject, best of luck. I hope that something will make sense in the next few minutes. If it doesn't make very much sense, I apologise, but at least you've got a framework to go and read the guides afterwards. The guides are for your personal use. For anyone who attends the seminar, you can keep them. You're very welcome to refer to them at a later date, but they are copyrighted to Landmark Chambers, so please don't copy them or circulate them or put them on your firm intranet without Chambers' permission. We're going to start with a discussion of some of the difficulties arising in CHC cases. And to that end, it gives me enormous pleasure to introduce the first speaker, Sam Broadford. Sam is a highly experienced public law silk and joint head of the public law group in Chambers. She has a very well-established NHS practice advising individuals and public bodies alike. She's one of the authors of NHS Law and Practice, which was published last October in its second edition. And relevantly for today's purposes, she's advised on numerous cases involving the most difficult issues around CHC funding, including restitutionary claims, dispute resolution, delegation powers, and a whole host of other issues. So I can't think of anyone who's more qualified and articulate to give this seminar this afternoon. Sam, over to you.
Thank you very much, David. Good afternoon, everyone. I'm going to talk to you about three topics in particular. First of all, PI settlements and CHC funding, how to manage CHC packages where the patient has a personal injury settlement, which was based on a claim to cover care costs, and then the interrelationship between the two. The second topic will be care provided by relatives, how to factor in care provided by members of the individual's household. And the third topic is going to be home care packages or transfer to a care home and the limits of a patient's choice. Turning then to the first topic, PI settlements and CHC funding, personal injury claims obviously consist of general and special damages. General damages address the intangible consequences of an injury, while special damages address the tangible financial consequences. So general damages compensate for the subjective, non-economic impacts of the injury, such as pain, suffering, emotional distress, and loss of enjoyment of life, and is usually paid as a lump sum. Special damages, on the other hand, seek to compensate for specific calculable financial losses directly resulting from the injury. And so examples could be medical expenses, past and future, social care required by an injured person as a result of the negligence, lost wages, past and future, property repair or replacement costs, travel expenses to medical appointments, rehabilitation, therapy, home modifications due to disability. Special damages can come in the form of a lump sum or as a series of annual payments for the remainder of an individual's life under a periodical payment order, which is also known as a PPO, and that used to be called a structured settlement. And some of you might know it in relation to that. Let me start with a disclaimer. I am not a personal injury lawyer and I don't negotiate PI settlements. However, starting from basic principles, you would think that if an injured party had sought and obtained a personal injury award for, amongst other things, future medical expenses and care costs, that they would not be able to bank the damages and then have a claim for NHS funding to meet the costs of their social care and accommodation needs. But there is a disconnect between the private law principles on which damages are awarded in the civil courts and the public law principles which govern entitlement to CHC. Whatever the basic principles of fairness and general prevention of double recovery, the position appears to be that patients do not lose the right to CHC because they are wealthy, because of a personal injury or clinical negligence settlement, just as they do not lose the right to apply for CHC funding because they are wealthy for some other reason. And that is a consequence of NHS services not being means tested. I should say that very often in practice, they do not lose their right to claim social care either because of damages in a personal injury trust or managed through the Court of Protection, because these are exempt from being included in any means test, but that's a story for another occasion. I've had to advise on cases where individuals have had a PI payout, including for future care costs, and then some years later claim and obtain CHC funding for those same care costs. Now, I advise on the law, as all barristers advise on the law, not on morals, but this situation seems to be fairly problematic, if I could put it as an understatement. However, this form of double payment does actually happen. So how does this happen? Well, the legal framework is uncontroversial. Section 1(4) of the NHS Act 2006, as amended in 2012, provides that the services provided as part of the health service in England must be free of charge except insofar as that making and recovery of charges is expressly provided for by or under any enactment whenever passed. In other words, Section 1.4 of the 2006 Act requires health services provided in England as part of the health service. They must be free of charge unless there is specific provision allowing for recovery of charges. There is no relevant provision at this time. Section 1I of the 2006 Act imposes the function of arranging for the provision of services for the purposes of the health service in England on an integrated care board established under Chapter A3 of the Act. Under Section 3 of the 2006 Act, again obviously as amended, an ICB quotes, must arrange for the provision of the following to such an extent as it considers necessary to meet the reasonable requirements of the people for whom it has responsibility. And I is such other services or facilities for the prevention of illness, the care of persons suffering from illness, and the aftercare of persons who have suffered from illness as the board considers are appropriate as part of the health service. Illness is defined in Section 275 as including any disorder or disability of the mind and any injury or disability requiring medical or dental treatment or nursing. The process of determining eligibility for CHC is contained in the 2012 Standing Rules, and in particular, Rule 21, which we'll come to in more detail in a moment, and of course, the National Framework for NHS, CHC, and NHS funding nursing care. So in terms of the eligibility process, let's start with a scenario. Take a person with life-changing, catastrophic injuries, perhaps as a result of a car accident for which they bore no liability, or as a result of medical negligence at birth. In both cases, the injured person has now got extensive medical and social care needs for life. The case results in a general damages claim and award in the usual way. Insofar as special damages are concerned, where the future care costs are likely to be very large, and as a rule of thumb, they can amount to 60% of any award for a younger person. So over time, this can be many millions of pounds. And it is quite common for that award, especially with large sums, to be structured as a periodical payment order, so as a PPO, with a certain amount payable each year. This has certain advantages, peace of mind, no worry that the lump sum investment will run out, easier to manage, tax advantages, etc. The injured person or their deputy, if they do not have capacity, commissions the care package from a private provider, and that's it. Or so one might think. Once the damages are awarded, then perhaps acting on advice at some later period, the injured person seeks a CHC assessment. And Rule 21 of the Standing Rules imposes a relatively low threshold for the duty to assess to kick in, i.e., when it appears to the body that, quotes, there may be a need for such care. The person is then assessed and, unsurprisingly, the question of whether they have a primary health need is determined in their favour. And the regulations then provide, at Regulation 21.6, if a relevant body decides that a person has a primary health need in accordance with paragraph 5b, it must also decide that that person is eligible for NHS continuing healthcare. So in other words, once you have an assessment, primary health need, you automatically have a decision that you are eligible for NHS CHC. The question then arises whether the ICB can lawfully consider it not necessary to meet the injured party's reasonable requirements by reason of their special damages award. In other words, could the ICB argue that once a person is in the position of having made an election to seek privately funded continuing care under Section 2(4) of the Law Reform Personal Injuries Act 1984, and is in receipt of such compensation, that they no longer have a reasonable requirement for the NHS to provide such care, or at least not insofar as such care is covered by the award. This argument was rejected in a case called Booker against NHS Oldham, and the reference is on this slide. And that case is cited as general authority for that proposition. However, in my view, the facts of that case are worth bearing in mind. In that case, the settlement with the PI defendant, who was insured with Direct Line insurers, was expressly agreed to be on the basis that the privately funded care would start at a later date, namely 15th of December 2011, which was at the time about 2 years further ahead. In the meantime, Booker would continue to receive the NHS care that she was receiving. And there was a clause in the settlement agreement which provided that if the PCT withdrew funding at an earlier stage, i.e. before December 2011, the PI defendant, through her insurer's Direct Line, would indemnify the claimant. So it was a sort of safeguard provision, or a step-up clause, as they're sometimes called. So on the back of that, the PCT did seek to withdraw the funding on the basis of the existence of the indemnity arrangements which were to operate in the period of up to December 2011. And they decided that this meant that the PCT was entitled to conclude that the claimant did not have a reasonable requirement for the provision of such care. Proceedings were brought and the court disagreed, holding that the PCT's decision to withdraw funding in the period up to the 15th of December 2011 was unlawful. And the core reasoning is in paragraph 27 of that decision. The court gave 3 key reasons. The first was that in deciding whether a service is reasonably required or is necessary to meet a reasonable requirement, the PCT is bound to have regard to the duties imposed by Section 1 of the 2006 Act. It follows that the PCT must have regard to the target duty to provide a comprehensive service free at the point of delivery. Second reason was that, and again quote, in reaching a decision, the PCT was bound to have regard to the NHS Constitution. It was therefore bound to have regard to the principle that access to NHS services is based on clinical need, not on an individual's ability to pay, and that a person who is otherwise eligible for treatment is entitled to receive it free of charge. And third, the judge stated that in his judgment, in reaching a decision in a case such as this, the PCT was bound to have regard to and indeed carry into effect the policy set out in the National Framework document. And this document established the national policy to be applied in deciding on eligibility questions for future healthcare. And he considered paragraphs 47 and 49 of the framework in particular, stating that these could not support the notion that a person should not be treated as eligible by reference to the ability of the person to access funding for such care from another source. And he said that paragraph 49 plainly contradicted such an approach. The reality is, he said, that this claimant's need for continuing healthcare will only be removed so long as a private package has been successfully established and implemented. Unless and until that had occurred, the principles set out in paragraph 47 of the framework document cannot apply. So as you can see, if you look at paragraph 27, and you've heard from what I've said, is that the judgment was concerned with an argument regarding NHS funding for a specific period in which the claimant had not opted for private care, and it seemed to have been accepted on all sides that once the private package was established with effect from the 15th of December 2011, the PCT was entitled to withdraw funding, or at least it was not suggested otherwise. And on the ordinary principle against double recovery, that makes perfect sense, because if the PI case had gone to trial, the claimant would not have been awarded compensation for the costs of care for a period during which she was not intending to receive privately paying care. So on the facts, Booker was concerned with a refusal to provide care in circumstances where the claimant had not opted for private care arrangements for that period, and accordingly no such award had been made for it in the settlement. And the existence of safety net arrangements did not alter the position. And in my view, the case did not address the situation where a PI award had been made for private care arrangements and the recipient nonetheless sought CHC funding from the NHS. In fact, that wasn't a problem that was likely to rise in Booker because of the terms of the settlement agreement, which included a series of undertakings designed to eliminate the possibility of double recovery. In practice, however, the reasoning in Booker appears to be applied much more broadly than the particular facts might suggest. We've come across a number of cases where the terms of the settlement agreement do not make adequate provision for the situation where, at the time of settlement, the intention is for a comprehensive, privately funded care package, which is then awarded, but some years later, the person applies for and obtains CHC assessment confirming eligibility, so that same care is then provided for via CHC funding, or either directly or more commonly through a personal health budget. And to take an example that I've encountered, a case in the context of a personal injury claim against the NHS was a birth negligence claim, was settled for a lump sum and a substantial PPO of some £200,000 a year. Years later, when the person was by then a young adult, an application for CHC eligibility was made, and now the care is paid for via CHC, but the PPO continues. So in that case, the taxpayer is providing funding for the same injury twice. This is not the only anomaly, but it is quite a striking one. There is no decided case on it, and Booker has stood unchallenged and does not appear to have been distinguished or confined in any other cases for over 12 years, in fact over 15 now. However, anomalies arising out of the current legislative scheme have been the subject of judicial comment for the last 15 years, if not longer. And in the specific facts of different cases, the courts have made clear that this is a matter for Parliament to resolve, not the courts. And examples other than Booker are on the screen: Crofton against NHS Litigation Authority and Forbes against Quinn, which is a Northern Irish case, but very interesting because in fact the funding authority wanted to intervene in the private settlement arrangements and was not permitted to do so. In relation to this point, are there any solutions short of legislative amendment? And in my view, there are a number of points that are worth exploring in the meantime. First of all, it seems to me that there is a specific power under Section 2B of the Damages Act 1996 for the Lord Chancellor to make an order enabling a court which has made a PPO to vary the order in specified circumstances. From my research, only one such order has ever been made under this provision back in 2005 and in circumstances which are not relevant to this. On the face of it, the power is broad enough to enable an order allowing a court to reopen and adjust a PPO in circumstances to prevent double recovery. And there's also a power to make an order for the courts to reopen the PPO in specific circumstances if the agreement makes such provision. Second, and in any event, I am not convinced, as you might have gathered from my exposition of the facts in Booker, but I'm not convinced that Booker should be seen, is or should be seen, the last word on this. Permission to appeal was granted, although not pursued, but in any event, I think there is a decent argument that it was not meant to be read as broadly as it seems to be, and it should be confined to cases where an ICB seeks to withdraw funding in reliance on the step-in provisions in the settlement agreement. The reasoning in paragraph 27 is also at least partly predicated on the basis that the PCT is bound to have regard to, and that is obviously right, and quotes, indeed to carry into effect the policy set out in the National Framework document, which on one reading puts the status of the National Framework more weightily than the court did in Wapples, where it was said that the National Framework must be taken into account, but it is not a directive, it is guidance. Thirdly, and perhaps most importantly, settlement agreements, especially those entered into by the NHS, should be drafted to include indemnity clauses or other provisions to stop this from happening. For example, there is a model precedent for this type of arrangement to be found in Appendix 1 of Foskett on Compromise, which expressly provides for a section for, quotes, any further series of undertakings relating to indemnities or otherwise. And indeed, in agreements that I have seen, in settlement agreements that I have seen, the Foskett model is used as the basis for the settlement agreement, but the provision, the bit that's in italics, which says insert any relevant indemnity clauses here, is just removed. Anyway, there may be PI lawyers in this audience who tell me that drafting around this problem is not possible for a variety of legal reasons, and if so, so be it, although I'd be very interested to hear what those reasons are. And certainly private insurers did it without adverse comment in Booker. So when advising an injured party with a PI settlement who may have a primary healthcare need, it is worth looking closely at the terms of the settlement agreement, because the person may not be precluded from seeking CHC funding for the same injury in respect of which they have already been compensated. My second topic is much shorter, and this relates to how to factor in care provided by members of the individual's households. An issue that also crops up not infrequently, and it's not uncommon that the care provided by a relative reduces the appearance of need and therefore affects the assessment. So, for example, take a Mrs. Smith, an 82-year-old woman with advanced Parkinson's disease, significant mobility issues and dementia. She lives with her adult daughter who has given up work to become her full-time carer, and the daughter provides extensive care, including assistance with all activities, medication administration, nighttime supervision due to the risk of falls, managing incontinence, etc. During the CHC eligibility assessment, the multidisciplinary team recognises that without the daughter's constant support, Miss Smith would require 24-hour care in a nursing home, and her risk of injury, malnutrition and neglect would be significantly higher, and the complexity and intensity of those needs would trigger higher eligibility for CHC. And so that's an example in which the daughter's care masks the full extent of Miss Smith's needs, making her appear less dependent. Now, the national framework on this is clear. Well-managed needs are still needs. only where the successful management of a healthcare need has permanently reduced or removed an ongoing need such that the active management is reduced or no longer required, will this have a bearing on NHS CHC eligibility. So in other words, decision-making should not marginalise a need just because it is successfully managed. This is easier to state than to apply in practice. It would obviously be unethical to remove the support in order to assess a person's need without it. But there are evidential problems. Specialist care providers may not routinely produce detailed recording of the extent to which a need is managed. And as the framework points out, it may be necessary to ask providers or relatives to complete a detailed diary over a suitable period of time. In addition, where care is being provided by family members, it may also be necessary to bear in mind that sometimes family members are incentivised to obtain CHC funding for financial reasons. The problem of environment can also swing the other way. Sometimes the need is exacerbated by being in an inappropriate environment, rather than because they require a particular kind of support. But again, there are evidential difficulties with that, very difficult to disentangle sometimes. There is guidance PG 23 gives further examples. And finally, the framework appears to draw a distinction between well-managed needs, which are still needs, and well-controlled needs, which are said to be those conditions which are well controlled by medication or other routine care or support and are therefore not meant to be considered needs in the same way. I think there's an element of angels dancing on the head of a pin here, but the point goes to show the importance of a well-rounded evidence-based assessment, and it is to be hoped that some common sense will prevail when considering the 4 characteristics of need and making an eligibility recommendation on the question of public health need. So how do you reconcile the approach? In my view, insofar as routine care and support provided by family members are concerned, in my view, the better course overall is to discount care provided by a family from a person's needs. This is the approach taken to accommodation needs. A person who has their own house doesn't need accommodation. Equally, where a person receives an amount of gratuitous care from their spouse, partner or other relatives, or even friends, the person has no need for NHS services in that area. And any other approach leads to the problem as to whether family members should be paid for providing support that they're already providing gratuitously. And this approach is particularly useful in circumstances where there is a tension between delivering care to a patient in their own home through a bespoke care arrangement and delivering care to a patient in a care home. I'll say a little more about this under the 3rd heading, but if this approach is taken, it can be possible to reduce the costs of the package to make it affordable for the person to remain in their own home, whereas if it wasn't, then the only affordable alternative may be to require the person to move to a care home. So the final topic is home care packages or transfer to a care home. So creating a bespoke hospital at home for a patient can be prohibitively expensive. Both hospitals and care homes work on an economy of scale model, which means that the cost of nurses, drug supply, support staff, and everything else that goes with it are shared across all of the residents, and none of these economies of scale operate when delivering care to a patient in their own home. But of course, the patient may well wish to stay in their own home, particularly if they occupy it along with other members of their family. How should an ICB approach the situation where the cost of care planning in the patient's home might be £250,000 a year, but a care home place which will meet their reasonable needs can be commissioned at a cost of £125,000 a year? The national framework is perhaps less than helpful in providing clear guidance as to how an ICB should approach this problem. It provides at paragraph 197 that the starting point for agreeing the package and the setting it should be the individual's preferences, but that in some situations a model of support preferred by individuals will be more expensive than other options, and that ICPs can take comparative costs and value into account when determining the model of support to be provided. But they should consider the following factors when doing so. A, that the cost comparison has to be on the basis of genuine costs of alternative models. B, where the person prefers to be supported in their own home, the actual cost of doing this should be identified on the basis of the individual's assessed needs and agreed desires outcome. So, for example, individuals can sometimes be described as needing 24-hour care when what is meant is they need ready access to support and or supervision. And then the framework suggests that ICB should consider whether models such as assistive technology could meet some of these needs. But equally, in my view, it might be that there's a spouse who can provide some of that supervision and would do anyway if they were still living in the same home. And in fact, this is recognised further on under that heading. And then C, cost has to be balanced against other factors in the individual case, such as an individual desire to continue to live in a family environment. And there's reference to the Gunter case, quite old now, and a practice note 46. Now, practice notes 45 and 46 are quite helpful, although reference to Gunter is perhaps a bit too highly stated. If this problem arises, so therefore the first question is to determine whether the ICB has a policy governing the situations. Many of them do. Some policies provide that patient's preference should normally be given effect unless it is more than 10% more expensive than the alternative. David tells me that the EHRC got quite vexed about that type of policy a few years ago and threatened judicial review proceedings, but in the end accepted that this type of policy did not breach Article 8 rights. If there is no ICB policy, then decision-making becomes potentially more complicated, but in general, it would take fairly extraordinary circumstances for Article 8 rights to impose an obligation on the ICB to invest substantial additional sums in funding a care package when there was an alternative that could meet reasonable needs. So those are my 3 hot topics for the day, and thank you very much for listening.
Thank you very much, Fiona. Thank you very much, Fiona.
Sam, even.
Sorry, Sam. Braining gear, David. That was, well, I think that tackled some really difficult issues. Certainly those of us who've been practicing in this area for a long time, these are the type of issues that keep coming up. And I see from the number of number of questions coming up, that there are a variety of views expressed depending on which perspective people come to. But before we go to questions, it gives me enormous pleasure in introducing Fiona Scolding, KC, to give the talk on children's continuing care. Fiona needs little introduction because she's extremely well known in this area of the law. She's been advising on disputes of children's continuing care for at least the last 20 years, including devising and advising ICBs, local authorities, parents, charities, other organisations about policies, procedures, and conducting dispute resolution processes on these issues and others concerning healthcare. She's an expert in education and public and admin law, frequently appearing at all levels of court litigating issues concerning healthcare, social care, the right to education, the needs of children, young people and adults with disabilities and health. She's currently representing the Department of Health and Social Care in the COVID inquiry and in the Nottingham inquiry into the murders of 3 people by Baldo Kakane. And she was a contributor to the first edition of NHS Law and Practice. But she herself says that she, quote, failed miserably to contribute to the second edition because she was too busy dealing with the needs of her clients. But she is therefore completely well qualified and superbly experienced to be able to talk about children's continuing care. Fiona.
Thank you very much, David, for that most kind introduction. Of course, I don't deserve any of it other than the fact that I miserably failed to contribute towards David and others' book. Now, I'm going to talk to you today about children's continuing care. It is different to adults' continuing care, and that is the first, the last. That's the first thing I'm going to say, the thing I'm going to say in the middle, and the last thing I'm going to say. Just a few tidbits and points. One, I have tried to find out how many children are currently in receipt of continuing care, but there are no statistics or figures that I can find. Hilary, would it be possible for you to put the slide up on my screen, please? The arrow key.
Yes, click the arrow key.
Do I have to click the arrow key? Oh, right, there we are. Right. So there are 52,096 people who receive continuing healthcare overall. That will include children. There are 34,000 of those that receive what's known as standard continuing healthcare, i.e. not the fast track end of life care. So it is a relatively small number of individuals. However, the total bill, I think in 2024, was £6.5 billion. I suspect it will be a little bit more. So it is quite a large sum of money for quite a small number of people. Now, those of us who practice in this area may well say, well, that doesn't surprise us that it's going to cost £6.5 billion, as these tend to be the individuals with the most complicated care needs and the most complicated set of difficulties in the country. But plainly, we are talking about a time of, I was going to say austerity, but I think we're now in super austerity, aren't we? Or extreme austerity. Penury might be more appropriate. And therefore, that £6.5 billion, I suspect, is the subject of the beady eye of the Treasury as we speak. I'm going to focus on 3 particular areas, and I would urge all of you to read the excellent download that came with the invitation to this talk. And also, if ever you're going to do something about this, to have a look at the national framework, which is old, 2016. It needs a refresh, I think. I suspect it may well be getting a refresh in the next couple of years, but at the moment, this is the document that you have to look at. It is a bit woolly and vague. That's my concern about it. It is not particularly clear about some of the issues that I'm going to raise today, but it's better than nothing. So there are 3 topics I'm going to deal with. Firstly, eligibility for such assessments, and how about gatekeeping, something which certainly local authorities tend to be exercised about when it comes to the relationship between them and the ICB. Secondly, decision-making about packages of care and disputes between public bodies, as this is an area where there tends, my experience certainly as a lawyer, is I tend to see more disputes between public bodies about this than I do between families and local authorities, although there are such, and I'll touch on them. And last but by no means least, because of the nature of children's continuing care, the interrelationship between continuing healthcare and other aspects of meeting children's needs by way of education and social care. So first things first, let's go back to basics. Unlike adult continuing healthcare, children's continuing care is meant to be part and parcel of an overall package of care for social services, education, and health. So the existence of children's continuing care is predicated upon the interpretation of Section 3 of the NHS Act. One of the things that has always I've always found quite interesting is why there was not or has not been post-Coughlin further statutory definition of what continuing healthcare means. My view is that it's convenient for it to be kept vague. Its operation is therefore different to adult continuing healthcare, although there are certain commonalities of approach. It only applies furthermore to those age 18 and under. So for those of you who are used to doing work which is either about education or about social care, you will note that there are no transitional arrangements from children's continuing to care to to adult continuing healthcare, other than the framework saying, oh, there should be such transitional arrangements. And so therefore there could potentially be that bumpy crossing when young people become 18, which the Care Act tries to stop by way of the extensive transitional provisions about assessments for those who are going to reach 18, and the fact that the education and healthcare plans can last until young people are 25. So that's the first thing. And this is something which comes up time and time again, which is, although continuing children's care is meant to be the same as social care and education, and you're meant to create this holistic package, one of the difficulties is, and this is something I have been talking about now for at least 25 years, is the fact that if you have different forms of statutory eligibility, you are going to have different outcomes, shall we say, in terms of who has to fund things and who can choose whether or not to fund things, and how that funding is allocated, which, let's face it, is largely what we're talking about here. Eligibility is set out under the framework as will be required when a child or young person has needs, and by that they obviously mean health needs, arising from disability, accident or illness that cannot be met by existing universal or specialist services alone. So obviously, again, a bit like adult continuing healthcare, we're looking at, in effect, a children's version of the Coughlin test, and we're looking at something which goes beyond that, which is usually available. Now, who are the children and young people who would usually qualify for that? I would suggest that they tend to fall into three brackets. Firstly, children with very complex physical disabilities, many of which are life-limiting in nature. So that would be people with various complicated and unusual rare diseases, genetic syndromes, factors of that nature. Secondly, I would say there will be a cohort of young people with things like cerebral palsy and or other very complicated health needs caused by what Sam mentioned earlier, the negligence of the state. And in this case, it's usually the negligence of the NHS itself by way of brain damage, injury at birth. Then there will be other individuals who have brain injuries at birth or as a result of road traffic accidents. And last but by no means least, you have a small but significant cohort of people who would so qualify because of their challenging behaviour. And they tend to be young people with a combination of mental health, emotional, social, plus learning disabilities, probably with some kind of maybe epilepsy or some complexity arising from their brain development at the same time. So the first issue that we have to think about is it does not, it could include, continuing children's healthcare and the provision made under it would be healthcare provision that should be set out in a child and young person's EHC plan, but it is not necessarily provision which is special educational provision. So the likelihood is that it has to be health provision which goes beyond provision which is educational or provision which meets Section 17 of the Children Act or Section 2 of the Chronically Sick and Disabled Persons Act, which is the current fundamental statutory basis upon which social care is provided for children. Now, as we all know, the Law Commission is in the process of producing and has produced reports in order to cohere children's social care. And it may well be that there is some legislative fiddling, shall we say, in respect of children's continuing care at the same time. So getting an assessment, again, getting an assessment or an initial assessment for whether or not a child qualifies for CCC should be quite straightforward, as the guidance stresses that there should be assessment if they may have needs that require additional health service. So that, again, should be a very low threshold, as Samantha talked about, in respect of adults. And it can even be a paper-based assessment to see if a child should proceed. Now, what a lot of local authorities who have come to me over the past 6 or 7 years have said is there's too much gatekeeping at this stage by health bodies, that there are a significant number of children where it is not clear, and the may have needs has been turned into must have needs, i.e. must qualify rather than may qualify. What happens if there are concerns about that, and about, firstly, either the threshold being put too high and or trying to think about the provision of services which in reality either don't exist and or are not practicable from a local authority perspective? Because the reality of CCC is you're often creating bespoke packages for these children and young people, either within their own homes or within foster care or within residential special schools, which I will talk about in a moment. So how do you manage disputes at the gatekeeping stage? The responsibility of deciding whether somebody may or may not qualify, whether or not they therefore should have an assessment, is that of the ICB, not of the other service providers. So we have to think about that. The statutory power to, there is no direct statutory power to assess. The indirect power is under Section 3 and what follows from that. And therefore, ultimately, it is a decision of the ICBs, not a joint decision. However, there should be, and every local authority and ICB should have, a dispute resolution agreement about these issues. My experience has been that either people don't have them, or if they do have them, they can't find them, or they're in draft and nobody's ever agreed them. I haven't actually ever seen one that has been in final form and has been implemented and is being used. So, I mean, that may well just be the cases that I get involved in. I'm sure the majority of the ICBs and the local authorities don't have that, but the ones that I've been involved in is that. So the first thing is there a dispute resolution document and policy? And if so, what does it say? The next issue is, my view is that the question of assessment should be the subject, if we're thinking about doing this in a holistic way, of true tripartite dispute resolution. Should there be, there should be at the very least some discussion with social care and education. If not, I would suggest proper consultation in order to create the kind of joint commissioning holistic approach that the guidance, that the Department of Health guidance identifies, but which is also replicated both in social care guidance and in the SEN Code of Practice. If you are representing social care and education at that stage, you may well wish to encourage parents, and if you're the corporate parent for local authorities, there will be a number of these children who may well either be the subject of compulsory care orders or may well be looked after children, because they may well be accommodated under Section 20 of the Children Act, usually because of the complexity of their disabilities, making their parents unable to care for them, to use the appeal mechanisms set out under the relevant regulations. Next issue to deal with is Children's Continuing Healthcare and the Children and Families Act 2004. Both the CCC guidance and the SEN Code of Practice suggest running the EHCP and the Children's Continuing Care processes together, and in effect operating them so that you create a holistic whole rather than a number of different assessments. Again, I don't think I've ever seen that happen in practice, because differing professionals' work time, work schedules, etc., often means it doesn't entirely cohere. But that is the aim. Note, however, that despite the fact that there is meant to be the creation of a coherent package of care, of course, who undertakes the assessments is different. The ICB assessment is separate to the creation of an EHC plan. It should be undertaken by a children's health assessor, although the local authority should be involved, and the health assessor is meant to lead on behalf of both bodies. Again, how does that work out practically? It's one of those things that lots of local authorities in particular and ICBs get concerned about, you know, who is leading this process, who is running it. Again, that's something that I think having a common set of agreements, set of principles, memorandum of understanding can help avoid the kinds of issues which can bedevil and create disputes between public bodies in this respect. There is also obviously the need for cooperation during these assessments. And just again, can I identify the differences between children's CCC and adult CHC in this respect? Firstly, the decision support tool is not the only tool to be used. Now, if you read the adult CHC guidance, it obviously says that the DST isn't the only tool to be used and you should look at all other factors. In practice, however, the DST is the sort of mechanism and the way in to getting CHC in practice, even though in the abstract there are other ways to get it. That is different for children. The preference, the assessment guidance makes it absolutely clear you have to look at the preferences of the children, the young person and the family. There must be a collation of holistic assessments, including for social care, the health needs of other family members and the environment in which the child lives. Reports from health, social care and education, including risk assessments and specialist assessments from all of those. And the reality is most of the children who would look like qualifying for children's continuing care are likely to be under a number of different specialist community and hospital services. So you're likely to have a large number of people who may well need to, whose views may well need to be incorporated. And you have to look at the decision support tool and the administration of that. What the guidance is absolutely clear about is there will be needs which fall outside the DST that children may well have. That does not disqualify them from having continuing healthcare. And two of the obvious areas which are identified are pulmonary cardiac issues, which may well be of some complexity for children and young people. So how do you resolve disputes about either the level of need in the DST, the assessments or the overall decision? And from this basis, I am talking about disputes between local authorities rather than between parents and the ICB, as that is the subject of quite a well thought out appeal process. I might not go further than that. CCC decisions are meant to be taken by a multi-agency forum or panel, but there is no guidance set out within the current framework as to how to work together, save for some woolly exhortations to, you know, kumbaya, my lord, and everybody sits and holds hands and, you know, sits around in a ring. Who gets the ultimate say? Should there be a balance? What happens if there's not agreement? What happens if, you know, you fall out about how you even create a dispute resolution panel? The guidance is miraculously silent on this basis. So my view is that this is when you phone the lawyer and ask them to inject either some common sense, if you believe that lawyers have common sense, or alternatively, an incredibly bureaucratic and procedurally unfair process, depending upon which way you view it. So possible dispute resolution, firstly, do you have a policy? As I've already identified, I often find that there aren't any policies in place. Secondly, if the policy should then say how you resolve the dispute, even if it's only in broad terms, if you don't have that, let's just adopt a common sense approach. Firstly, it goes up the chain to director discussions. That tends not to necessarily solve anything, although sometimes it does, as the words "let's split the difference" often appear at that stage. If not, you then have to think about, Do you go to chief exec discussions? My view is that may not be needed, as it may well be something which is best dealt with by the ADCS and the ICB Children's Healthcare Lead, as they're likely to be the ones with the most detailed knowledge and understanding. If you can't reach agreement at that stage, then the question is do you go off and seek independent evaluation? If so, by whom? A neighbouring ICB, a neighbouring local authority, a neighbouring panel, which is meant to be made, an independent expert? If so, who do you get to do this and who pays for it? And most importantly, can the decision be delegated to that individual? Now, David, Sam and I have had a discussion about this. We think that it is possible under the relevant standing regulations and the relevant general NHS rules to probably agree that a decision can be delegated to an individual who is making such an independent evaluation if it's done as part of dispute resolution. However, you would have to get the relevant standing orders and regulations in place for that delegation to take place. And my view is that's really complicated. My preferred view is to say, ultimately, it's still a decision which has to be taken by the panel. So any independent evaluation, I would suggest, is more like a recommendation, a bit like you do with adult panels, and that avoids you delegating something wrongly. Secondly, avoids issues with whether or not you can delegate these decisions or not, which I think David, Sam and I have had a lively discussion amongst ourselves. And thirdly, it therefore also replicates the adult decision-making process, which is that panel makes a decision. In practice, however, the reality is if you're commissioning that out because you can't agree, you would usually say, well, recommended, say for, you know, these are the following reasons why we can't agree with it. And there would obviously be the possibility for judicial review if those reasons weren't good and adequate. The other thing we always have to think about is funding pending the outcome of the dispute. I have known people toss a coin in these circumstances. Sometimes tossing a coin is just as sensible as any other way forward. Or what lots of local authorities or NHS Trust do is say, look, let's split the funding down the middle, whilst we are trying to sort out between us who is responsible for this. So we both have some impetus to try and resolve the dispute as quickly as possible in order to identify the proper allocation of funding and responsibility. So following on from that, it will often be the case that there will be a request for CCC funding as part and parcel of a request for a young person or a child to be placed within a specialist residential setting, whether that's a specialist rehabilitative hospital. The most obvious one I can think of is Tadworth, though that's been the subject of some discussion, shall we say, lately, or the sorts of specialist settings for children with complex sort of PMLD and or complex epilepsy that we can all think about. There aren't very many of them in the country, but those which they are very expensive. So there may well be a request for CCC and or a request for funding on that basis. Obviously, Section 26 of the Children and Family Act 2014 identifies the need for joint commissioning arrangements for those who have SEN, but that's obviously a general duty and not a specific individual duty which can found a judicial review. Again, the things that you're going to want to be thinking about is who decides and how do you decide if a residential placement is needed and who's going to fund what. And this is where everybody tends to fall out with each other, is in the who funds what rather than necessarily who makes the decision. Because everybody tends, my experience has been that if he gets to the stage where a child has got very complicated needs and has cycled through the local system, very often the only option is a specialist residential placement, particularly if young people are exercising significantly challenging behaviour alongside their complicated health needs. So who funds what? That's usually when everybody scraps with each other, which is to identify, well, I only want to pay for this bit, I don't want to pay for that bit, or I don't think I should have to pay for any of it. Obviously, there are limits as to who has the powers to pay for what. So, for example, a local authority cannot fund medical care for children, just as it can't fund medical care for adults. Section 22 of the Care Act 2014, although it is not of direct relevance to children, it is a useful pointer and has been used to say those are the limits of local authority, the ability of local authorities to pay for provision. But don't forget, the Education Authority is ultimately responsible for paying for and arranging special educational provision, even if it is provided by a health body, and obviously a local authority is responsible for providing the other forms of special educational provision and the social services provision. Now, one of the difficulties that again comes, and this is because there is not parity of outcomes or parity of legislation, that the first tier tribunal has the right to make orders about special educational provision, but can only make recommendations in respect of health and social care. So what should really happen is you avoid arguing about who does what by having a joint pooled fund under Section 75 of the Health Act or under Section 26 of the Children and Families Act. So you have this pooled funding, which is, can be attributable to anyone, and then, any of you can make that decision. In particular, I would urge you to think about adopting that response for a number of young people who might fall into CCC on the basis that there is always considerable overlap between what's considered to be healthcare, what's considered to be social care, and what's considered to be educational care. And the reality is that it could be intelligibly allocated, I would say, in a number of cases, to all those three buckets and pots, depending upon what perspective you come from. And that's particularly the case in respect of challenging behaviour, those with emotional and social needs, and those with communication difficulties. And again, think about the different duties between the bodies, which is health, and health has only a discretionary duty to meet the needs under the Health Act. But obviously, if they do decide to meet those needs, it has to be free. Social services have a mandatory duty if under Section 2 of the CSDPA, they have assessed and have a plan which says that something should be met, but that can be charged for, although in reality, very few children ever end up, being charged for such on a practical basis. And education, obviously, there are a series of mandatory duties to train or educate. EHC plans, the next thing just to identify is that CCC should be set out in Part G of any EHC plan. Again, sometimes you see it, but very often you don't see it. And if it is in Section G, then firstly, the local authority has to get the healthcare provider to agree to it. So you can't put anything in local authority unless the healthcare provider has agreed to it under the relevant regulations. But secondly, once it's in, then the responsible commissioning body is under a mandatory obligation to arrange it. So if you are a parent and you want to guarantee that relevant healthcare set out under Section G, which is in effect healthcare which goes beyond that which is set out in universal services, then you make sure it goes in there, and then if it isn't provided, that provides you with a route for judicial review. Then again, if it is special educational provision, as I've identified, then ultimately it's the obligation of the local authority to arrange it, and that is a non-delegable mandatory duty, even if in reality the ICB, community services, various hospitals, social services provide it. Appeals to the first tier tribunal, the other area where your CCC, if you're an ICB or a local authority you might be thinking about, is firstly parents asking for recommendations to be made about continuing healthcare and social care in appeals to the first tier tribunal. Those appeals have gone up from, I think, something like 10,000 appeals a year in 2015 to 24,000 appeals last year. So there's been an absolutely ginormous increase. So it's taking now well over a year for decisions to be made before the first tier tribunal, which is not satisfactory for anyone. But think about the fact that your local authority is ultimately responsible for organising those appeals and for defending them. But you as a health body should be involved in that and should be asked to consider issues if there are going to be, as the first tier tribunal can do, is make recommendations to you as an ICB about what you should be doing and what should be set out in section G. If a child has a need for health and social care services which go beyond universal services, the ICB and the LA are, however, the sole decision makers about the extent of the services, and that is not subject to an appeal to the FTT. So you cannot run a continuing care CCC appeal by the back door as a parent. I should also identify, for the avoidance of doubt, that nursing care has been found not to be special educational provision, and therefore that can only be, if it can't be special educational provision and it can't be pursuant to sort of implying section 22 of the Care Act, it can't be provided by social care. It therefore would have to be provided by the ICB. Whether or not that needs to be by continuing care or whether or not that can be provided by way of community nursing services is the question that often has to be discussed. As I have said before, special educational provision, however, is not necessarily simply exclusively educational, and very often there are arid and I would suggest somewhat artificial debates and discussions about what counts as educational and what doesn't, which judicious use of a pooled fund can avoid, although obviously we all like having those discussions as lawyers. Thank you very much for listening to me. We now have times for questions. We are going to try and answer as many questions as possible. I will now go and sit down, and we will sit and attempt to assist you as much or as little as we're able given the time of day. Thank you very much.
Thank you very much, Fiona. Wait till we scan the camera around so you can see all three of us. Thank you very much. Right, we have a whole series of questions. I'm going to try and get through as many as we can in the next 10 minutes because inevitably, being barristers, we've taken slightly longer and we started slightly late. The first question I want to raise, which I think is for Sam, the question which is, what's the legal standing of an ICB kicking off a reassessment of a continuing health care package without any evidence that changes have occurred since the last assessment? Sam.
Thanks. They are supposed to reassess every year in any event. So the national framework makes that clear that you can reassess once in a year, and indeed it's good practice to reassess once a year. So that's a perfectly proper approach.
Right. The second issue I'm going to raise is that it's been suggested that an inner London local authority has reached the view that the threshold for CHC eligibility and joint funding has been raised by effectively the ICB team since the pandemic, and that chronic health needs in the borough are now not being met by CHC, because even people with who need 24-hour care are now being assessed as not being eligible for CHC. Can the local authority lawfully challenge the change in policy from the ICB? I think we can give you some very, very general views on that, but obviously it depends on the specifics. Sam, do you want to start?
I would start with, first of all, look at your dispute resolution policies and start there. And secondly, if one was to bring a challenge it could only be brought, I think, by judicial review, it would be quite a complicated thing to do because it would effectively be a systemic type challenge, and you'd have to look very carefully at what evidence you had for reaching the view that the ICB had, for example, raised the threshold and then that was in a way that was unlawful. And so that sort of problem should really be taken to a lawyer to sort of work out almost a strategic plan as to how to best manage those sorts of problems and to see what the prospects of such a challenge would be.
Yeah, I think you want to add to that.
I mean, yes. I mean, I think the first thing you would do is look and see if under the dispute resolution process that you have that sits on your desk that's beautifully up to date, is to have a discussion, and to have a discussion if necessary at a very high level. I mean, don't forget that the ICB and the local authority are meant to be working together to improve the public health of the general public, and there's various responsibilities assessments for adults and for children, for everybody, as I've suggested, to sing Kumbaya and hold hands with each other. So, that is the general thrust of it. So I think you want to try and look at, what is this actually doing? What is the actual problem that we're trying to solve here? And is there a problem at all? I mean, the reality is that the ICB can change the framework, can change the goalposts. It's a discretionary obligation, providing that it is meeting the needs as set out and is following the national framework. There is no reason why it can't change the approach it's taken, and without it necessarily being unlawful. I mean, I would probably say, if you were to think about judicially reviewing, I mean, obviously to the three of us, that's music to all of our ears. But the pragmatic side of me would say that the first thing a judge would say is, why have I got two public bodies fighting with each other? There have been such discussions, and there have been such judicial reviews brought in the past. And the first thing that's nearly always said in whichever judgment is, it's extremely sorry that people are spending this much money on disputes between themselves rather than on the health or social care of the individuals concerned.
I think I agree with that. Obviously, the ICB are required to use the decision support tool, and that's part of the process they have to follow under Regulation 21 in reaching the decision. So if they're not using the DST to make these decisions, then they're acting unlawfully. However, if they use the DST, but in practice, the way that the multidisciplinary team are approaching the assessment has been, in a sense, toughened, and they're therefore reaching clinical judgments in a case today that somebody only has a severe need rather than a priority need, or a medium need rather than a severe need, then it may be extremely difficult to identify a legal issue which you can latch onto merely because a difference of approach has been taken. I mean, there are different approaches across the country, even though everyone is working to the same national framework and the same decision support.
I just looked this up. The Nuffield Trust did some quite interesting research last year, which said that there was a difference in approach in eligibility between local authorities. From some of them, I think it said sort of 3.6%, somewhere like Cornwall. I'm sorry, I'm not meaning to traduce Cornwall if it's a particularly low one, but it was literally the difference between that and Rutland, which I think is a much smaller ICB with far fewer people. Something like 45% of people who were assessed were seen as eligible. I mean, it's not really possible because of the population differences and the differences in the nature of the people and their health needs. But I mean, there are wide variations in approach in respect of who is deemed eligible for CHC across the country, both in respect of adults, and unfortunately we don't have any research about children.
On that, can I thank Tamsin Lewis from the Southwest regional lead from NHS England, who's helpfully told us that her understanding is there are about 3,900 children and young persons in receipt of children and young persons continuing care. I should point out that in the 2016 guidance, there's a reference to children and young persons, but actually that means children in terms of the Children Act definition.
It means children, it means people up to the age of 18. Obviously, in healthcare services, often children stop at 16 because obviously after the age of 16 they become able to make their own decisions by and large about medical treatment, although actually this group of young people are likely to be the group of young people who are likely to lack capacity to make those decisions at all times. Thank you very much for that, Tamsin. Thank you for giving me that. I shall take that away and treat that as gospel. So again, we're looking at quite a small number of young people, but the likelihood is that the cost of those packages are likely to be, I would say, minimum £200,000 a year, maximum probably in the millions a year.
I'm going to raise what I think is a very, very interesting and anonymous question which has been raised. There are many ambiguities relating to exceptional circumstances where a family member can ask to be paid for caring for their loved ones in the home when they may have grown up. Family often provides a better standard of care, understand the person better, and often experts by experience. I should say, I think that's a really good way of expressing it, experts by experience. ICBs tend not to mention this. They prefer when one doesn't know about it. There is often a massive impact on the ability for one member of the family to go to work due to such caring needs, yet they receive nothing for the amount of care they give. What experience do any of us have in this field? That's an issue I've certainly dealt with. I could kick off and
You can cover.
The first thing to say is families vary enormously in the quality of care that they provide. And in this area, also remember there's somebody in the middle with very severe health needs. But by and large, my experience over many years is that family members are astonishingly committed to supporting their family member. And many of them are astonishingly informed. I remember one, he was a retired professor of engineering, and he said, what you have to understand is I am the world expert in looking after my daughter's medical condition. I can't look after anybody else, but whenever she goes into hospital, the doctors ring me up to ask me how to manage her condition because I've done it all the time. So the second point is the question the right to say the economic effect on family members who provide that care can be huge? Answer, yes. Absolutely right. It can be absolutely, their dedication and commitment can be phenomenal, and they pay a very heavy price. Next, the question, and this I think is a really, really difficult question, is if they get continuing care, can they say, well, actually, the best person to be paid for caring for this is me? The answer to that has got to be dealt with on a case-by-case basis, but the guidance does not exclude it.
No, and it can be done if it's included in a care plan under, there is provision to do so both under social care direct payments and under NHS direct payments, which identify that it may be secured if it's necessary to meet satisfactorily the patient's need for that service or to promote the welfare of a patient who is a child. And that means someone who is living in the same household, whether or not they're a family member or a friend. So that is Regulation 5A and 5B of the NHS Service Direct Payments Amendment Regulations to 2017. So there is, the answer to that is there is power to do so. There is, usually that comes with a number of fairly onerous responsibilities in terms of financial accountability, agreeing to professionally agreed care plans, talking about proper contracts of employment, record keeping, insurance, all those various factors which have to be looked at. But the answer to that is technically, yes, it can happen.
Right. I'm going to do, we've got time, we're running over, but I'm just going to do with two final questions. First of all, it's a question about Peter's agreements or Peter's provisions in settlement agreements. I've been told that where a person has compensation settlement to cover care costs negotiated with NHS resolution, the settlement now usually incorporates something called a Peter's agreement, which means that while the person will be eligible and may receive CHC funding in the usual way, NHS resolution can claim compensation funds from the person if they do so. Is that correct, Sam?
It is correct that some agreements contain them, but my experience has been I've seen agreements without anything at all. And so you end up in the situation that I was describing in my talk. The Peters Agreement issue has arisen out of a case originally involving a deputy where the deputy agreed to some self-imposed limits so that the scope of their retainer as deputy was limited by the undertakings that had been given, which included effectively not to do things so as to end up with double recovery from memory. But the clauses have been drafted to do to have similar effect to prevent double recovery, but they're not in all agreements.
I'm going to make 2 points very quickly in response to that. First of all, they only really work for periodical payment agreements. They don't really work for one-off capital settlement payments. Secondly, there was a very interesting case, I think about 18 months ago, where a judge in a case, and I think it involved Sheffield hospitals, but I'm not absolutely certain. I can't quite remember. I haven't got the details in front of me. Basically told the claimants that if they wanted to claim the future cost of social care and healthcare as part of any schedule, he required them to include a Peters scheme within any settlement agreement, and simply said from the bench that is mandated. I thought that was very interesting. Whether or not the judge has power to do that is a very interesting question. That's what a High Court judge did. The last question that I think we've got time for, is another one about children. So it's one for you, Fiona. We have many children and young persons who use BiPAP breathing equipment overnight, but we would advise they do not meet children's continuing threshold as they score too low. But I'm told CSC view, I think must be the local
children's social care.
View is they score higher. How do we challenge the health practitioner scores in children's care assessments?
Right. Okay, well, this is something which comes up quite a lot. Breathing equipment and suctioning tend to be two areas where there is often dispute about who can do it, etc., etc. I mean, the answer to that is obviously to use your dispute resolution, because this is plainly something where there is a difference of view. Don't forget that whether or not somebody meets continuing children's care and the nature of that assessment and package and who pays for what should be the subject of a multi-agency panel under the framework agreement. So this should be exactly the kind of discussion that you're having in your multi-agency panel, saying, well, I think this and you think that, and who provides it and who doesn't. I mean, I'm very reluctant to give any specific advice about BiPAP breathing equipment, because some of it's going to also be about how skilled the parents are at using it, who provides it, whether or not the carers have been trained in using it, whether or not a registered nurse has to come in, if somebody's there overnight, are we talking about people who need night waking, not night waking? There are all sorts of different ways. I mean, I think it is one of those things that there can be objectively two different clinical judgments as to whether it's necessary or whether it's not, as to whether it meets priority or high in respect of the breathing categorisation. And so I would suggest it's one of those things that you may well need to either agree to disagree, secondly, do something practical, which is agree to split it down the middle if you can't agree, or thirdly, use your dispute resolution and use your multi-agency panel to have those kinds of discussions, because that is what they are meant to be there for.
I think that's right. The only thing I raise finally is this is the type of case where it plainly doesn't fall within section 22(1) of the Care Act, because it's not a service that's required to be provided.
No, it doesn't have to be actually administered by a registered nurse, albeit that there will be reviews, I suspect, by a registered nurse in respect of the use of that equipment.
Yeah, so it is classically one of those areas that could be provided either by social care or by the NHS, and that's precisely the sort of area where the multi-agency panel
where the multi-agency panel is meant to be there, and where the idea of having a pooled budget means you don't have to worry about it anymore.
Ladies and gentlemen, thank you very much. I can see that a very large number of people have stayed to the end. Can I thank Sam and Fiona for what I thought were excellent, hugely informative presentations. I'd like to thank everybody for the contributions they made on the chat, many of which started to answer some of the questions that were raised.
Yes.
And it's clear we have a very, very expert audience. So I hope everyone's got something out of this afternoon. Thank you very much. If you want to see it again, this will be available as a download after this seminar. I know there's been some people who had difficulty in accessing the guides. We will make sure that they are recirculated, so with links where you can click to download the guides. Thank you very much for your attention, and I hope you found this afternoon interesting. And that's the end of the webinar.
Fabulous. Thank you so much.
Thank you.